What a crazy weekend. So I was kind of wrapping up a little bit on Friday to start my weekend, like everyone. And then I saw the news or announcement or proclamation, uh, whatever is the right term. And I was like, oh my God, how is this possible? So the next whole weekend completely I got so many messages. I spoke with lawyers, because I'm active in the immigration space. The whole weekend got very chaotic. So uh, I am luckily not in the stage of like struggling with the H1 visa myself at this moment because I have gone through the journey. Because I have gone through the journey, I realize that how much stressful it can be for people who are looking ahead or are in H1B. They want to transfer, irrespective of what's the condition. Either H1B is ahead of you or you are transferring. I know that there is a lot of stress and confusion. That can you travel inside? Can you go out? There's just way too much confusion. So um, the reason for this webinar is that just wanted to clarify my confusions, and hopefully whoever is present, we can also solve theirs. And I'll make a quick introduction of basically me and Algorizin, and then the kind law firm we have today who jump to help us so quickly in such a quick notice. So a little bit of my background. I'm Siam, if someone doesn't know. Uh, I have been running communities for immigrants for a long time. I started with a nonprofit 10 years ago. Then I run a for-profit where we help immigrants primarily to navigate life in the US and bringing together vetted immigration guidance and give them job landing support and almost like a whole stack support for their immigration journey. And Fakhoury Global Immigration, FGI, I'll refer it to as FGI, is a top-rated US firm which has 25 years plus experience of supporting high-skilled professionals and entrepreneurs. From FGI, we have Benedict and Melinda, immigration attorneys with a global background, and they specialize in employment-based immigration like EB1A and EB2 NIW. They have helped hundreds of high-skilled professionals and entrepreneurs navigate life in the US. So thank you so much again, Benedict and Melinda, for doing this on such a short notice, and also Paulina, who is in the background from FGI, for orchestrating this whole thing. So um, I think without further ado, I think everyone has a lot of questions. How this session will run is that we'll take the first 15-20 minutes to go through a quick presentation of who got affected, who is not affected, what are the confusing parts, and what are the details of this whole proclamation, and how does it affect you. And then we'll use the last part of the session for any kind of questions you have. And in the meantime, if you have any questions, please make sure you're just asking it in the chat. And that's it. Hopefully we have a useful session. So I'll just pass it to Benedict and Melinda for presentation.
Thank you very much. We will get started. We're going to go ahead and do a little bit of background as to why we're here and what happened with the proclamation, how it was rolled out over this past weekend, and then go through what we know about the proclamation, what's still yet to be determined, and then look at some alternative visa options for those of you that are interested, and then finally wrap up with the Q&A, which is probably what most of you are most interested in. So we'll just run through this really quickly to kind of give a background of why we're here today. So to begin with, on Friday, we had a very interesting day where the White House issued a proclamation called the Restriction on Entry of Certain Non-Immigrant Workers. This caused quite the disruption in the community because it read much like the travel ban. If you lived through the COVID administration where we had travel changes change almost immediately and with very little notice, this was a very similar proclamation that was not expected. The proclamation itself was very short. It went through the basis for this issue in that the current administration sees H-1B employers and H-1B workers abusing the purpose of the H-1B program to the detriment of U.S. workers, and the minimum prevailing wage, specifically within the IT field. As a result, the action of the proclamation was imposing a restriction to the entry of US workers in absence of a new $100,000 filing fee, which is quite hefty and quite unexpected to immediately impose. The proclamation did leave an exception to be issued by the Secretary of Homeland Security if the foreign worker was entering the US to further the national interest without posing a threat to US security and welfare. So this was a very, very brief proclamation, which raised quite a few more questions than it provided answers, and also created a large amount of confusion because this proclamation was set to go into effect, announced on Friday, effective on Sunday. So as you can imagine, there was a lot of concern about what exactly this meant, who would be affected by it. So announcement on Friday, the agencies that were impacted and were intending to enforce this proclamation almost immediately started issuing memorandum clarifying what exactly this meant. So on Saturday, the 20th, USCIS, who is the agency responsible for issuing decisions on immigration petitions, sent out a memo clarifying that this travel restriction only applied to future H-1B filings. So any petition filed after the September 21st deadline, that is who would be affected by the new additional fee. Looking backwards, anyone who had approval in hand or a pending application on the 21st was not implicated by this new proclamation. CBP, which is Customs and Border Protection, in charge of actually enforcing entry and who is admitted to the US, also issued a memo clarifying that any individual who had an H-1B approval and a valid visa was not implicated or impacted by this new proclamation. So anyone with an approval in hand or a visa in hand when this proclamation was issued was not impacted by this new travel. The following Sunday, Department of State and USCIS also issued more detailed FAQs, reiterating that the $100,000 fee was applying to future petitions after the 21st, and that travel for current H-1B holders and current valid visa holders would not be impacted. So this was all over the span of this prior weekend. And as you can see from the issuance of these memos, all of the different governmental agencies that are impacted by this proclamation are somewhat scrambling to give clarifications and provide additional information that just wasn't included in this proclamation when it was initially announced. So what we know now following the weekend are several key points. The $100,000 fee is not going to be an annual charge. This is a one-time fee that will be related to H-1B individuals entering the US for the first time. It will only apply to new petitions that are filed after the September 2025 deadline. There will be some exceptions to this rule. It's a little unclear what exactly that will have to be, but there is going to be at least some exceptions to this initial $100,000 filing fee. Current H-1Bs are not affected. So again, if anyone is an H-1B holder with an approval notice in hand, with a visa in hand before September 21st, will not be impacted by this new $100,000 fee moving forward. As part of this proclamation that was getting a little less news, the administration directed the Department of Labor to also look at the prevailing wage system, which is the minimum prevailing wage set by the Department of Labor that each H-1B worker must be paid. This should be interesting and will develop moving forward, but we do expect that the Department of Labor may start revising the minimum prevailing wage requirements. I highly doubt they will go down, so I am expecting this to be somewhat of an adjustment to require higher wages in the future, but that's something that the Department of Labor will have to update moving forward. The biggest takeaway that we know is that travel will be unaffected again, for H-1B visa holders who currently have the visa with an approval, travel should not be interrupted by this proclamation. So existing travel that's already been approved should be fine moving forward. What we don't know and what hasn't been clarified from the initial proclamation and the following memos, these questions will still be determined. We can give our best estimate or what we think might happen based on what's already taken place in this current administration. Some of the points that we are unclear about are the adjudication of H-1B renewals, change of employment, and amendments. This initial proclamation was based on entry to the US. So H-1B holders who are currently outside the US entering the US for the first time. That was the limitation of the initial proclamation. We don't think that this will apply to individuals who are currently in the US, who are applying for renewals, extensions, potentially change of employers and amendments. This additional fee should not apply to those individuals, but USCIS and the administration has not concretely come out and affirmed that that is correct. We think it should be applying, but again, we don't have black and white guidance from USCIS in this point yet. Another issue that remains unclear is first-time visa issuance. So the visa is the sticker that's actually attached in an individual's passport. So with an approved H-1B petition on the first trip outside the US, most individuals must then apply for a visa through the US consulate to be readmitted back into the US in H-1B status. It is unclear if this proclamation will apply to those individuals who have an approval but are making their first entry to the US in H-1B status. That's just a point that's unclear right now, and how those new entries will be treated, even if there is an underlying H-1B approval. We'll hopefully get more guidance on that moving forward. Another point that is unclear on is how this new fee will be treated for cap-exempt petitions. So all H-1B employees are either subject to the annual cap, which goes into the lottery process, or they are a cap-exempt organization, meaning they can file an H-1B petition at any time during the year. Previously, cap-exempt petitioners had a great advantage in that they didn't have to go into the lottery process, but it appears under this proclamation that those might be treated as new petitions, which would be subject to the new $100,000 filing fee. Again, we don't have guidance on this issue, but the cap-exempt petitions seem to be the low-hanging fruit that will be at least immediately impacted by this decision.
And Melinda, this could be a huge disadvantage, especially because cap-exempt employers tend to be nonprofit, universities, things of that sort, correct?
Correct. This will also most likely impact individuals who are looking at doing startups or entrepreneurial endeavors. Will probably be the first petitions that are impacted by this additional fee. Looking forward to the 2026 H-1B cap lottery process, we know that this process will be different than it has in years past. The administration just yesterday announced that they are trying to consider a more weighted selection process based on the offered salary. So that might look different for the cap lottery process. The cap lottery process will also all be new petitions. So individuals who are filing their first H-1B petition. And it seems, based on what we know so far, that those initial H-1B petitions may be subject to this new $100,000 filing fee. The administration has not come out and explicitly said that, but based on the guidance that they have provided so far, this seems to be somewhat the second target of this increased fee. And it will absolutely apply to individuals who are outside of the US and entering the H-1B cap lottery. That is very clear that those individuals will be affected by this new fee. Another unknown we have right now is defining what exactly the national interest exception will apply to. That has not been defined in this proclamation. We can look backwards towards the exceptions that were made during COVID and the national interest exceptions that were made during that period to get an idea. This will most likely cover areas that are important to energy, healthcare, any sort of national interest related to the government. But again, we don't know because this term hasn't been defined, and it will greatly depend on how broadly they define national interest and what specific fields might qualify under this exception. And then lastly, just as a matter of logistics, we don't have any information on how this $100,000 fee can actually be paid or documented that it was paid. Right now, CBP hasn't said that this can be paid at the airport. The Department of State has not said this could be paid at the consulate with the visa application. I'm fairly confident they don't want individuals showing up at the airport with briefcases full of $100,000. But again, we just don't have any information right now on what that looks like or documenting the fact you did or did not pay it. So that will all be in the logistics moving forward that needs to be clarified by the USCIS and the CBP for future petitions. One thing that we know is 100% clear is that this will be challenged in court over the weekend within 24 hours of this announcement. Private individuals, public companies were soliciting individuals to file lawsuits. I'm not aware of any filing that has been made to date, but I'm confident that by the end of the week, there will be at least one challenge to this proclamation going into effect. So we'll kind of see and have to wait what the outcome of those challenges are. So we wanted to leave you with some practical guidance, not just open-ended questions. So for the employers on this call, things that you can look at is starting off by identifying what your current H-1B population is. Who are those employees who could potentially be affected by this? And look at the timing of extensions for them, amendments for them. As a rule of thumb, we recommend starting the extension process at least 6 months before the current expiration date. But given this current guideline, I would recommend much more, maybe looking at 8 months beforehand, looking at what those extensions are going to look like and making sure you're timely filing those. International travel, especially if you're an international business that requires individuals to travel, you need to evaluate when those individuals need to be traveling, if they have the proper documentation, and just strategize much more ahead of time. There should not be any last minute international travel. So it's just something to prepare for. Again, the Department of Labor is going to be reevaluate the prevailing wage levels. We don't know what that will look like, but we do suspect they will probably be higher for H-1B sponsored employees, just based on the tone of the administration and their concerns about the negative impacts to US workers. And then lastly, for employers, looking forward to the 2026 H-1B capped lottery process, we don't know exactly what that will look like or the new changes that will be implemented, but it's always important to identify those individuals who might need to be put into the lottery process early. Those will likely be F1 students who have graduated, individuals looking to switch from other statuses. But again, this is all proactive advice. You want to make sure you're looking forward and have plenty of time to strategize based on the current changes that we see going on right now. On an individual level, the advice is very similar. If you have international travel plans, that's something that you're going to have to plan ahead much earlier than we had previously advised individuals to look at. Perhaps, avoid international travel if possible until we have more concrete guidance. For individuals who are on the current H-1B approval with a current visa stamp, we do have guidance from USCIS and CBP that your travel is not impacted. But I would caution very extreme to not travel unless you absolutely have to. As we saw with this Friday announcement, things can change very quickly with little or no notice. Related to that, also, as we are confused about how these regulations are implemented, the individual CBP officers who are at any given airport are also getting very mixed messages about what the current state of regulations are, what they should be imposing, who is subject to these new rules. So if possible, I would caution to delay international travel right now.
Melinda, the bigger alert would be, of course, also the unknown for people who are doing a change of employer, who need a new visa for some reason, going to the consulate. We just don't know what's going to happen there, right?
Exactly. If you do not have a visa and you need to travel abroad and apply for a visa before you can re-enter, I would be very cautious about doing that right now until we have more guidance from CBP, from USCIS, is exactly who will be affected. And I think the worst case scenario is that you get to the airport and a CBP officer expects you to come up with $100,000 fee. And then it just makes for a very disruptive experience for travel. So if possible, I would recommend delaying travel until we have more guidance.
And
That
unfortunately,
also,
there's a question that says, when are these clarification expected to come? And unfortunately, we have no idea. You know, it seems like the administration is just figuring it out as we are. Sorry, Melinda.
no, not at all. I think that's very true. And if someone on the call knows the answer to when we will get all of our answers, I would love to know that, because we also we had a very interesting Friday night, and the weekend continues to be interesting as the government agencies are releasing their own memos, and they are also figuring out how this will be implemented and what their steps are moving forward. But with that being said, H-1B is still possible. It's in flux right now. But with that, there are alternative options. H-1B is not exhaustive or the only option for many individuals, which is why Benedict is here, so she can share our expertise on some alternative visa strategies that it might be a good time to consider looking at.
Hi, guys. Thank you so much for joining us. I know everybody has lots of questions. Like Melinda said, you know, the H-1B is still feasible, but we do specialize in other alternative options. So we just want to raise awareness, you know, kind of keep that in a back pocket. Again, like Melinda said, we are fortunate in the immigration field to have brilliant minds who have been working nonstop since Friday evening, have hardly gotten any sleep, so they can file litigation as quickly as possible and getting this overturned as quickly as possible. But in the meantime, again, it's always important to consider your options. So the first ones that you will see, the O1A, the EB1A, and the EB2NIW, those are what we call the self-petitioning options. That means that you get to go around the traditional route of an employment-based visa, where you need an employer to sponsor you, and you can do it yourself. Because they are the exception to the rule, they are, you know, much harder to get. You know, as you guys may know, the O1A and the EB1A are referred to as the extraordinary ability visas. The difference between the O1A and the EB1 is the O1 is what we called a non-immigrant visa. That is a temporary visa, and that you can get up to 3 years. The EB1A is actually a visa that leads to the green card. But as you may know, the categories are very similar in that we have scholarly articles and leading critical role. high salary, judging, national awards. So if you don't have a big international award like an Oscar or Pulitzer, you can still have, if you're an academic, a researcher, it may be that you have publications that are heavily cited. If you are in the business world, an entrepreneur, maybe we can show leading role. So those, again, exceptions to the rules, but are viable. Another exception to the rule is what we call the national interest waiver, which falls under the EB2 categories. There are two ways to qualify for the national interest waiver. Advanced degree, the most common way. Either you show you have the equivalent of a US master's degree or the equivalent of a US bachelor's degree plus 5 years of post-baccalaureate progressive experience. You can qualify under another way, called extraordinary ability, but that's usually for self-made entrepreneurs who didn't finish their degrees but have 10 years more of experience. The tricky thing about national interest waiver is that you have to show that because you're not being sponsored by an employer, you have an endeavor that it will be of substantial merit and national importance, something that USCIS, US immigration has been heavily pushing back. So it is a great mechanism for entrepreneurs, for self-made people, but more and more, we really have to push on that endeavor. So really show what you're gonna do in the US once you're approved. But of course, these are the exception to the rules, and you should always consider the traditional route, right? If you have an employer and they're willing to sponsor you, you should look at those options. What are those options apart from the H-1B? Well, for the non-immigrant visa, if you work for a company abroad for more than a year and then came here, or are thinking about coming to the US, we could possibly look into an L1A. If you are a Canadian citizen or a Mexican citizen, we could think about a TN. Other options could be an E2 investor visa. If you're from a treaty country, we could think about an E2. So there's lots of viable options. And of course, we can't ignore the families, right? If you have somebody who is a US citizen or legal permanent resident, would they be able to petition? So at this time, given the current status of the immigration system, you really want to look at viable options, especially if you're on a non-immigrant employment visa. Can your employer do a labor certification and a perm for you? Yes, as everyone must know, this is a very long, a very tedious process. But in terms of approval ratings, it's the top that you're gonna get, right? So we specialize in alternative routes, but we do the traditional routes as well, because it's, again, where we are in the immigration system, we have to consider all viable options. And of course, if you have enough of money, also, I talked about the E2, but there's always the EB5 as well. All right, next slide. So Melinda, do you want to take this over or should I go through it?
Sure. So we just wanted to leave you with some key takeaways, just looking at, making sure everyone feels comfortable that the new proclamation is for new petitions starting after September 21st, that individuals who have the H-1B approval and a valid visa are still able to travel internationally, but with just extreme caution. Things will be a little in flux with international travel for at least the next few months. There are definitely uncertainties on exactly how this will apply to future filings, specifically the 2026 cap lottery process, cap-exempt petitions, and what exactly that exception criteria will be. Looking forward, being proactive, planning early are your best actions right now. Be strategic in your travel, be strategic in sponsoring individuals, look for alternative pathways. if the employer is not willing to pursue an H-1B, or if you just have a better option based on a self-petition like an O-1A, an EB-1A, an NIW, there are alternative routes outside the traditional H-1B. And lastly, just stay informed. Things will continue to change. We hope to have more guidance coming out over the upcoming month or two. And if you do have questions, talk to your employer, seek immigration advice. CM is very helpful, and all the individuals that he has helped with on their immigration pathways. So just those are our key takeaways of what we do, what we don't know, and kind of some general advice moving forward. But I know it seems like there are a lot of questions, so we'll move on to what I think everyone is looking forward to in that.
Thank you so much. This is very helpful. I actually myself got a lot of clarity. So let me just dive into the questions because there are a lot and I want to be mindful of your times. So I will read the questions out loud and I'll not mention the person's name because I want to be respectful to their privacy. So one question is that, is an H-1B amendment for a worksite employer with the same, H-1B amendment for a worksite change with same employer filed after 9/21 affected by the proclamation?
So we don't have specific guidance from USCIS that it will not be impacted. I think it's a very low chance because, again, the proclamation is for entry to the US by H-1B workers. That's very specific to individuals coming into the US for the first time, is where this $100,000 fee is attaching. Again, we don't have specific guidance from USCIS, but our best advice and our looking forward is that amendments, if it's only a worksite amendment, change of employers, if you're maintaining H-1B status, just moving to a different employer, or extensions based on a previously approved H-1B, we believe those will be processed without the additional fee. That's the information we have. I think that will be fairly confident that that's how USCIS will process. For a number of reasons, this will be challenged in court. The administration does not have the authority to impose a new fee directly on a new immigration filing. So I would feel fairly confident those categories of amendment, change of employers, will not be impacted in the immediate future.
But Melinda, we still have, it's still kind of unclear whether if there's a, if the USCIS were to accept the change of employer without the fee, but the applicant needed a new visa, we're still not quite sure what would happen at the consulate, right?
Correct. So the amendment, change of employer, extension of status is referencing to an individual who is in H-1B status remaining in the US. As soon as we talk about traveling or applying for a visa sticker in your passport at a US consulate, that is what might trigger the proclamation. And that's going to be a very case-specific analysis on whether that fee will then attach as soon as you leave the US and are seeking to leave.
Okay, thank you. So I'll go to the next question. Do you know if this will impact the current H-1B cap-exempt workers and their H-1B extensions?
We don't know. It's unclear. So again, this proclamation is directly referencing new petitions. So if the cap-exempt H-1B has already previously been approved and you're seeking an extension, that has not been categorized as a new petition by the USCIS historically. So it's not definite. We have not gotten guidance from USCIS, but on its face, what we know now, that is not a new petition and should not be subject to the $100,000 fee.
Yeah, thank you. I realize that this is so, I mean, the one issue with this whole thing is that this is still in flux and is still being formed as we speak. So every day is an update. So I think we do have to have some kind of follow-up. So I'll drop actually both Algorizin's LinkedIn page and also FGI's page. I would say like both of the pages, maybe whoever is the participant, you can follow for like future updates, because I think the rules are going to keep updating for the next couple of weeks, I feel like. So let me, yeah, sorry.
I think it's important from, this is kind of a personal point of view also. It's a point that's being still clarified, but I also think that what we called the clarification on Saturday from the related was also the government kind of backstepping, right? So it was great to have some clarification, but that clarification kind of juxtapose what is said in the proclamation per the references, to the rules and regulation. And so that's part of it, the unknown, as they're clarifying, it's kind of in conflict with what they originally said, creating more confusion.
Yeah. All right. So next question is question on change of employer inside US, but visa stamping expired in passport. 797 is valid till 2028 with current employer. It's a question. I don't know if this is a fully formed question. But that's
So,
yeah.
So again, anyone remaining in the US, applying for extensions, applying for a change of employers, we believe should not be impacted by this additional fee. Where the unknown part comes is if you are leaving the US and you have to apply for a new visa sticker in order to re-enter an H-1B status. That is the unclear part on whether or not this proclamation will be triggered and the additional fee will apply. Because while you remain in the US, you are not filing new petitions, you are continuing on your previously approved H-1B, but as soon as you leave the US, you then are making a new entry into returning to the US, and that is what is unclear and might trigger the additional fee. But remaining in the US, continuing employment or changing employers should not be impacted by this new proclamation.
And this is I think this is the most commonly asked questions, at least for me personally. This was that, does it affect for new H-1B applicants who are in the US but changing their status from OPT to H-1B?
So that will depend a little bit whether or not the individual was picked up in the 2025 lottery and has a previous or has in hand an H-1B approval. If you are changing status from F1 to H-1B, you were selected in the 2025 lottery, you should have an approval in hand or a pending petition. So that should not be impacted by the new proclamation. For individuals who,
if they don't have,
go ahead.
No, that's my question.
For the 2026 lottery, I think the questions are
correct.
Oh, yeah. Okay. For the 2026 lottery, it appears right now that fee would apply. So in the spring of 2026, if an individual is entered in the lottery, picked up in the lottery, and filing their first new H-1B petition, at least right now, it appears that filing fee would attach to those. And it will attach to individuals potentially in the US and definitely those outside of the US. So if you are currently outside of the US, you enter the 2026 spring lottery, you're picked up, your H-1B is approved, that fee, at least right now, will attach to those petitions when you try and enter the US for the first time in H-1B status.
That is very, very sad. So like anyone who is, I guess like probably keeping yourself updated of the new rule changes is the mandate, and also like looking at alternative, like this is the only thing you can do at this stage, I guess.
Yes. So for those individuals who are F1 students going into the 2026 cap lottery, at this point, there is nothing to do because the rules are still in flux. The administration is at least proposing new changes into how they run the lottery process. the Department of Labor is reevaluating the prevailing wage levels. So there will be a great amount that will change in the next months before the registration period opens. So right now, I think it's just a matter of staying informed, being in touch with your employer, being open about what the process and the changes are. And then, in the early 2026, we'll hopefully be in a much better place with more concrete answers about what that looks like.
Yeah. Another question, how does it impact current F1 students who are seeking future H-1B sponsorship for both cap-exempt and non-cap-exempt? I guess like we covered part of it, but yeah, how does it affect for cap-exempt? I guess is the question.
So to cap subject, if you're seeking a private employer, you'll have to go into the spring 2026 lottery. We've had that discussion about what those potential changes could be. If you're seeking a cap exempt employer, again, right now, it looks like that fee will attach to cap exempt employers. Until we have further guidance, we can't say for sure, but right now it looks like that will attach.
Okay. How does this affect when H-1B is transferred from one employer to another? Also, what happens if there is a change of status?
So filing a change of employer, I think we've talked about. I don't think the fee will attach at that point, but we haven't got clear guidance. Change of status, that depends. That goes back to if you're an F1 status changing to H-1B, are you subject to the cap or are you looking for a cap exempt employer?
Yeah. Yeah, I'm seeing similar questions, so I'm kind of like skipping. There are a lot of like F1 to H-1B related. I think this one Paulina answered, but I'll still ask, any assumption on the salary range if the H-1B becomes a selective process based on skill and salary?
Higher?
Yeah.
So during the first administration, Trump 1.0, a similar rule was proposed. It did not go into effect. So this is version 2.0 of the proposal to change the prevailing wage levels. I think it will change based on their proposal, but just what they are proposing is that the higher the wage level, so 3s and 4 wage levels, will be given a statistically higher chance of being selected. They'll basically be weighted instead of a true random lottery process that we have.
And unfortunately, from what they revealed yesterday with the weighted system, it looks like that's just purely looking at the wage, right? And not anything to do with the skills.
Okay.
And I would please not ask anyone to explain exactly how that will work out, because the weighted system and what they'll be giving weight to, they'll still have to develop how that will work. The end result will just be higher offered wages, more likely to be selected.
Okay. I think there are like sort of two questions. So how does this impact pending H-1B applications and any probable RFEs for students who are in STEM OPT inside the US? Like they have a H-1B pending approval at this moment in 2025. I guess, yeah, that's one question.
I have an answer to that one. We have been given concrete guidance that as long as the petition was pending as of the 21st, even if an RFE was issued, that will not be subject to the proclamation.
Yeah. And if there is a revision of wages, will that impact them who already got H-1B approved?
It will not be retroactive. It will be for future filings. So it would be impactful when an extension is needed. Yeah.
One person asks, when are these clarifications expected to come? We don't know. I can answer this. I don't think anyone knows that. Honestly, this is something.
I want a crystal crystal ball would be very useful right now.
Yes.
So we have to all use the crystal ball for this one. Um, one person asked, I mean, this is, I'm just asking serially. So Melinda and Benedict, if you think that, okay, this is not answerable, just say that and we'll move on. So this is not really H-1B related. What are the chances of someone getting a B2 NIW approval if they don't have publication and has 4 years of work experience in workforce development?
I would say and fill out our questionnaire online so I can get a more detailed look at your resume. It really national interest waiver. It really been doing this for years. You know, it's really a case by case. So really have to look at your overall experience and that. And so the more complete a resume and the more complete you submit, you know, to the questions, the more we can have, you know, one-on-one talk about your profile and whether it's suitable for a national interest waiver.
Yeah, so yeah, that and I think there is a link on how they can communicate with. Is it the direct FDI website? Then we can just push it.
So it's for our department, it's the FGIHSI.com.
Okay.
FGIHSI, and you fill out the questionnaire, which allows us to evaluate your profile better, and then we'll be in contact as to setting up a consultation.
Perfect. Yeah, I'm also dropping it here. We'll also send it in email later so that they have it handy. Okay, let me just see. I lost the train of questions here. Just give me a second. Okay, I'm just trying to going on serial. So we have it's not a, yeah, I mean, for EB2 NIW, if you get approved, are there going to be longer wait times because of high demand for the visa? I mean, I guess yes.
Wait, yes. I mean, the answer is I saw that question too. We're already there, right? Unfortunately, my clients who got approved at the beginning of 2024 just got current, right? So it's already a long wait. Unfortunately, that's, you know, a result of, you know, the popularity of NIW. So yes, you're waiting for, you know, at least 2 years, three. It's gonna be a wait of a couple of years. We don't know, you know, it of course depends on the visa bulletin that's issued by the Department of State on a monthly basis. But I always refer to the national interest waiver as a long-term solution, right? So meaning that you have to have a short-term solution to be in status while awaiting for the EB2 visa to become current, if approved.
Yeah. Question for NIW, US Masters plus 5 years of experience. Is that, I mean, good?
Bachelor's. So it's either, just to qualify, you either have to have the equivalent of a US master's and or the equivalent of a US bachelor's degree, so 4 years in college, plus 5 years of progressive experience after the degree. And that's just to qualify. And then we get to the fun part of, you know, substantial merit and national importance and all that jazz.
Okay. For a Canadian, implications of moving from H-1B back to TN, is there any implication?
There are differences. I would say number one difference is H-1B status is dual intent, meaning you can have an H-1B and pursue a green card. TN status is not. So if you are looking forward to a green card, there are some timing issues. You know, there are additional benefits from going to the TN, but that's a much more detailed analysis of what your specific career path is.
Okay. All right. So another NIW question. For the NIW petition, am I correct in understanding that the requirement is to pursue the proposed endeavor once adjustment of status is granted rather than beforehand?
Yes, it's upon approval. So it really is in the future, which makes it kind of tough, right? Because we're talking about 2-3 years down the road for something that USCIS is really pushing back as to what you're going to do, a 5-year plan, pretty elaborate. So it's, yes, but that is correct. It is upon obtention of the green card.
Okay, and regarding the salary weighted system, what I believe is the salary is different from different states in the US. So in that case, does being in a state where salary standard is less, will someone earning in New York be compared to someone earning in Arkansas?
We don't know yet.
Okay.
Mm.
Understandable. All right. Same question on cap exempt H-1B. Is it affected? I think we already covered that. F1 OPT, this is the biggest question. I'm just kind of like reading the things. Same question on STEM OPT.
That is the big one.
That is the big one, yes.
And on a practical effect, Melinda and I were speaking last night and preparing for this presentation. As we're still awaiting clarifications, that means employers are still waiting for clarifications as well. So unfortunately, I think it will have a practical effect in that, employers won't be readily offering H-1B because of these unknowns. And so that, that is the, something that is what is disheartening in all this is, the concrete effect of this proclamation on businesses and employees in our economy.
Yeah, and
As well as schools.
Especially schools.
yes, this was the question I was just looking at, that do you anticipate significant decrease in incoming international students due to this proclamation? So I had a discussion with like a few other like immigrant change makers in New York City, and the biggest thing which I was so sad about is this whole signaling of this issue is that globally US is going to lose so many talents, like just because, I mean, whoever is here and whoever is already in the path, that's a little different story. But people who are just graduating from, I don't know, like just high schools in different countries and they want to had a dream, just this news itself will, all right, we'll just go to Canada or Australia or UK or China or not US. So that's like the more sad.
And yeah, and this is kind of doubling down what was happening to international students at the beginning of the year, right? It was already a difficult couple of months. What happened with the revocation of the student visas and all the confusion that caused. I'm sure that didn't help either kind of selling our wonderful universities. But I think this is going to kind of double down in the sense that not only is a student visa kind of liable to the administration. But also, if you're not sure to be able to stay on and get a job and pay for that tuition, unfortunately, that is going to have a big effect on our universities.
Yes. Yeah. I want to be mindful for everyone's time, so I'll just like wrap up with like few more questions and then with some next action items. So one person is asking, do we have physical office? Yeah, we are in Tribeca in Manhattan. Let's communicate by email. And then got picked in this year's lottery and petition already got approved. H-1B activates October 1st, 2025. Can I go back for stamping after October 1st, or should I wait and see?
You can, you shouldn't. So I would wait. So that is the exact scenario that is an unknown. You have an H-1B approval, but you will be making your first entry in H-1B status after you obtain an H-1B visa. So you are in the exact scenario that might be triggered by this proclamation. So I would not travel until we have clear guidance from USCIS.
Yeah.
Congratulations on being selected. And good luck with your new job.
Yeah, I agree. Yeah, I think we have answered most of the questions. There are some repeat questions. So the action items from my side, I would say that like following both of our company pages, because social media is probably one of the best ways to be in touch for the loop, because this is such a like moving topic, and next couple of months will come with a lot of movement. Benedict and Melinda, is there any like ways for them to stay in touch with you and your team and being updated if you want to share some things?
There's a couple ways you can do that. Of course, the best way, especially if you're interested in a consultation, is to go on fgihsi.com website and fill out our questionnaire. You're more than welcome to connect with me on LinkedIn. Melinda's as well on LinkedIn. You can email me as well. But again, the questionnaire is really the best way. So we have a real idea of your profile and can direct you the best way. And I just want, the last thing I said was kind of a downer. I do want to end on a positive note. Just saying that, again, we are fortunate, again, to have brilliant minds in this immigration fields all over the US who have been working tirelessly since Friday night to overhaul this, right? Like Melinda said, suit has not been filed yet, but it's coming. People are working really hard so we can open this system back up.
Sounds good. Well, I mean, I wanted to thank again Benedict and Melinda and also Paulina, who is supporting us in the background. Thank you so much for pulling this off on such a short notice. And yeah, for everyone who is attending, thanks for joining on a Wednesday, like 2 p.m. I think we dropped all of our LinkedIns. Please, like if we missed something, just DM me personally, DM Benedict, Paulina, or Melinda, like just add all of us. And yeah, thank you so much. Hopefully things are going to get better and just stay in touch.